Good morning. What's the announcement?
Oh, I'm sorry, Judge, we filled out plea bargain rejection.
I don't see it yet.
It must be in the air.
Okay. All right. Let's go through that. Sir, you're Davin Kalina
Yes, ma'am.
and Mr. Kalina, in cause number 24, DCCR 2432, you're charged with a third-degree felony offense of injury to a child, elderly, or disabled individual from September 27th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a document that you've signed with Mr. Kelly. This a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be to plead to the lesser included class A misdemeanor, what, just an assault or?
Yes, Your Honor, just an assault. And it would probably be refiled. We would
Okay.
put that as the rejection.
Gotcha.
And if we are, I think right now it's best to put it on the trial docket. I think we prepare trial very quickly. If for some reason I am able to resolve it with that refile and some pretrial matters, I will do that. It will be off the school stuff.
Okay, thank you. And so what the offer is for a 2-year deferred probation. You have every right to reject that and to have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
And if it sounds like if there is something that gets worked out before that trial docket, then it'll get taken care of down the hall in a misdemeanor court. But I want to make sure you understand if that doesn't work out and you're still on this trial docket, that I won't accept this plea agreement once you're back here and set for trial. Do you understand?
Yes, ma'am. We understand.
Okay, so I'll get it set on the trial docket. Again, if something works out, just let us know. We'll get it taken care of.
We'll do that.
Right.
Thank you.
Thank you.
Yes, thank you.
Stay in touch with Mr. Kelly. He'll let you know when you need to be back and to which court.
Thank you,
Okay.
Judge.
Good morning, ma'am. Are you Ashley Sanders? And this is 24 DCCR 1650. Ms. Sanders is charged with theft of service. I think we've been waiting on
This is also.
the audit. So everything's done as far as discovery, and now we've got the rejection, correct? So
Yes.
Ms. Sanders, you're charged with a second-degree felony offense of theft of service. And that's from February 1st of 2019, continuing through May 31st of 2023. And what that means, ma'am, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kelly that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be for a 10-year deferred probation. You would be required to pay any restitution back and follow the rules and conditions of probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are, if you understand all of that. And do you want to reject that offer and have your case set for trial? Is there
Just to be candid with the court so that Ms. Sanders is aware, that offer obviously contemplated the court's authority to change the length of that and also a restitution hearing of sorts so that we
Sure.
can kind of figure out, if that's an appropriate amount of time, if the court thinks less is appropriate. I just didn't want her to feel we put it up there at the top to give you that latitude.
And if y'all, would that make any difference? So I do want to make sure that after today, Ms. Sanders, you understand that once your case is on the trial docket, I will not accept this plea agreement unless there's new evidence that your attorney or the state's attorney discovers. Do you understand? And do you want to reject that and have your case set for trial? All right, we'll get it set on the trial docket and Mr. Kelly will begin preparation for trial.
Okay.
Thank you.
Thank you.
Good morning, sir. Are you Aaron Wars?
Yeah.
And Mr. Macon, will your client waive the formal reading of the indictment?
Yes, sure.
Mr. Wars, in cause number 25, DCCR 1253, you're charged with the third-degree felony offense of driving while intoxicated, third or more. And that's from October 26th of 2024. Your indictment alleges you were previously convicted of driving while intoxicated March 27th of 2018, and then again, May 18th of 2023. And how do you plead to that charge?
Guilty.
And are those two prior convictions true?
Yes.
And did you enter your plea of guilty and true freely and voluntarily? and because you did what they charged you with. I have here on the tablet some documents and have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Macon? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 10 years. You would have a $500 fine and be required to follow all of the rules and conditions of probation.
10 days in jail starting this Friday.
I have to sentence him. He has to be sentenced.
Yeah.
I can't sentence him today. I have to get a pre-sentence report.
Okay.
So the 10 days will have to be after that pre-sentence
Yeah.
report. It's mandatory, but it won't start this week. So what'll happen, is that your understanding of your agreement though? Okay, and we'll talk about the 10 days in just a minute. Do you also understand, if you're not a US citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Wars is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Do you have, as a condition of your bond, the auto ignition interlock device on your vehicle?
I do.
So you're not driving? Okay, I do want to make sure you understand that if you get a vehicle, you cannot drive any vehicle unless it has that auto ignition interlock device on it. You understand? Right. And then that 10 days, again, when you come back for sentencing, that's when you'll either start it that day, or if you're working, then I would consider starting it a different day that weekend or something like that. So we'll talk about that at sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right over there. Okay, we'll see y'all back at sentencing.
Okay, thank you.
Thank you.
Good morning, sir. Are you, you're Kevin Boyd,
Yes, yeah.
and this is 26 DCCR 0227. Mr. Boyd is charged with driving while intoxicated, third or more. And Mr. Mitchell, what is the announcement?
Judge, we're asking for a little more time. I've spoken with Mr. Smith this morning. I've been out ill, severely ill, so I just need a little more time to get with Mr. Smith in his office.
Any issues?
Okay.
And Mr. Boyd, do you currently have that auto ignition interlock device on your vehicle?
I have a monitor, home monitor. This is.
Understand. I don't think that's.
You're not driving.
Home monitor.
Yeah.
4 hours.
So, did the magistrate give you that? Who told you to get that instead of the auto ignition interlock device?
Where they have them. Where I got it.
Okay, so here's the problem is, and I'm running into this, apparently we're having some issues with the magistrates not giving out it's mandatory on a DWI third to have the auto ignition interlock device.
Right.
So. Okay. So that one does say it. So you are required to have that auto ignition interlock device. So you need to change.
Oh, well, we just put it in the car. If you don't drive that car, you don't drive that car.
You can't drive any vehicle unless it has it. All right,
That's
so
what I'm saying, it won't be a drive.
that's fine. If you don't drive, then you don't have to have it.
Okay.
If you
But-
don't drive, continue doing the device, the breathalyzer type or handheld device.
Because you're not driving at all, right?
You're not driving now?
I have driven, but not.
Okay, you cannot drive starting today unless you have that auto ignition interlock device on your vehicle. It's a condition of your bond. So it's been a condition of your bond. It shows since you got out. So it's very important that you follow all of those conditions that were placed on that original bond. If you don't, you raise your bond, you go back to jail. Nobody wants that. So make sure you talk to your bondsman. You're clear about all of those.
This transcript shows how heavily U.S. courts rely on plea bargaining and pretrial negotiation instead of full trials. Judges repeatedly explain charges, sentencing ranges, and plea offers while ensuring defendants understand their rights. Many cases are pushed toward trial dockets or deferred sentencing, highlighting how the system balances efficiency with due process while giving defendants multiple chances to accept or reject agreements.
Okay.
Conditions. They can't change a condition that the magistrate ordered or that's required by law. So make sure, I don't know if,
I don't know if it was the provider that gave it to him.
yeah, the providers, where'd you get the handheld?
Johnny.
Johnny's?
Yeah.
Make a note for me to make sure they're not making that. Okay, all right.
So I need to monitor.
Yes.
If you don't, if you are not driving,
No, I'm not talking, talking about.
yes, I want you to have something.
Okay.
All right, so
Not-
go ahead and keep that.
No,
If you're not gonna drive, use the other 4 hours. If you are gonna drive, go ahead.
So are you Rakeem Allen? So Mr. Allen was here not that long ago, and we figured out when we were in court that day that there had been 15, I think it was, positive drug results, patch results that we had not received. We received them that day. I raised his bond on that day, went into custody, has made that bond, has a drug patch on, and the first drug patch received tested positive.
that was the one I had. That was the one that I had.
So you still had the one in court when they didn't take, you didn't take it off in jail? How long were you in jail?
I told him, I got out, when I got out the next morning, I told me to go change it.
Did you?
Yes, ma'am.
So when are you supposed to switch this one?
I just did a switch Monday.
Oh, you already did the switch Monday. So we should have a result within what, a few days, Anna? Do you know how long that takes? Okay, well, that at least somewhat explains that if that's correct. So I want to make sure you understand, obviously, I'm going to get that result within a few days. If it's positive, it's your bond's gonna be high enough to where you're not gonna just make it out overnight. Do you understand? If you test positive again for anything, you will be back in custody. We'll have a hearing. And at that point, based on the length of time, there are sometimes I can make findings that bonds are not even appropriate. So you better not test positive. You better not be around anybody that's doing it. You better not come in and say, I didn't do it. I touched something or somebody touched me. No excuses. This next one better be negative, okay? All right, y'all are free to go.
Thank you, Ron.
I'm sorry, Judge.
Yes,
I didn't want to interrupt you. In light of his criminal history, would the court consider, now that he's back out on bond, a GPS monitor in this case?
what's the underlying offense? Okay, I mean, he showed up every time. And there's not necessarily a complaining
I
witness.
just wanted to ask. It's
Okay, yeah, I would say if there's any other
If something
issues
comes
that
up, I'll
comes up, let me know and file something. Otherwise, my main thing, he's been here every time. We just didn't realize he was testing positive for that long.
I did.
All right, you're free to go. All
Thank you.
right, Mr. Crane. So you are going to have a baby today, is that right?
Yes, ma'am.
Well, here's what I'm going to do. Your attorney's talked with me. The assistant district attorney is not arguing against me doing this with what he's requested, but I want to make sure you understand what all of this means. I'm going to let you turn yourself in this Friday at 12 o'clock noon. All right. So that gives you a couple of days to get everything taken care of, see the baby born, and then you have to turn yourself into the Jefferson County Jail by noon on Friday. That's part of your probation now. And so what that means is if you don't turn yourself in on time, it's a violation of your probation. And so you're going to be right where you don't want to be, right? So I know you don't want to go for those 3 months, but it is intended to help you make better decisions. 3 months is better now to miss out of your child's life than potentially 5 to 99 if you violate your probation. So go listen, get the tools you need, turn yourself in, make some positive changes so that you don't ever have to look at me in this position again and we're not here having some really bad conversations, okay?
Yes, ma'am.
So I'm going to let you go today. I'm going to let you turn yourself in on Friday. And then hopefully everything goes just like we already talked about and you change your life and we're in a good place, okay? All right.
Thank
You can
Judge.
go back and they'll let you go from back there.
Another key theme is the strict enforcement of probation and bond conditions, especially in DWI and felony cases. The judge emphasizes compliance with interlock devices, drug testing, and supervision rules, showing how violations can quickly escalate to jail time. At the same time, the court also considers personal circumstances like medical or family situations, reflecting a mix of accountability and limited flexibility within the system.